Hey guys, and welcome to the weekly docket. Morning. Let's try this live with some updates on crazy cases. Switch this up here a little bit. And I normally don't have it prepared like this because I normally pre-record it, but let's go to Wisconsin with Darrell Brooks. Here he is holding someone else's money and probably someone else's hat. So what's going on with him? He's facing shooting charges, of course, where he shot at one of his relatives and I think a female who was in a car trying to flee. And his final pretrial conference for that is scheduled for this Monday. I've got that set up for a live stream, but I don't control whether the judge is going to actually do this hearing then or we'll stream it. But we'll see. If he does, we'll watch it. They should cover final issues and things like that because his trial date for those cases is July 10th. And this is the male judge, Judge David Feiss. So originally he was scheduled to have the charges involving Erica Patterson heard first and tried first. But of course, as you know, those got delayed and leapfrog past these. And the Erica Patterson charges, let's talk about that next. Battery and intimidation and probably bail jumping, I think, is in there too. The pretrial conference for that is now July 21st. The defense asked for this delay for some reason. August 14th trial date. And this is a female judge. Her picture is here. And we'll see what happens with that. I got a lot of comments about this last time when we talked about this. Why prosecute these charges? Is it a waste of time? Is it worth it? And some of the reasons I saw for a waste of time, or why not, was it's a waste of time and it's a waste of money. It's a waste of resources, and it's an additional platform for the scumbag. And it's hard not to argue for that. I agree. But why do it though? Her crime, in my opinion, Erica's crime against her, running over her, threatening her, and things like that, it's not less important. It's important. It's also typically insurance for the other convictions in case they did get reversed on appeal. But I agree with people saying that's not going to happen here. I agree, but that's often a reason to keep pursuing these kind of charges. I mean, look at Murdaugh down in South Carolina. They keep convicting this dude and trying him for other things besides murdering his family. I've seen people say this, and I think this is a fair point. The DA in Milwaukee is saving face for the earlier release because if these crimes had been tried earlier and his bail not reduced, he wouldn't have been on the street the day of the parade, right? So I could see that. I also put in here a little blurb that I found in case, and I don't know this to be the case, but in case Erica has had some of her expenses paid by the Crime Victims Fund, then she's supposed to cooperate with them to move forward with the case if they want to charge this guy and take him all the way to trial. And that seems fair if the state were reimbursing you for expenses. I don't know if that's a factor here because I haven't seen anything where Erica's like, yeah, I don't want to do this. It seems to me like she does. And if she does, I think it's fair to move forward with it. But I understand there are other opinions on that. Let's see. We got some comments coming in here. And thanks for this. When people do this, it generally ends up enabling me to improve the graphics of this broadcast. And the more graphics, the less me. So I think that's a win-win for everybody. All right, let's see what else is up with this nerd who's in the wheelchair there. I like that picture of him because he is a man who nobody tells him what to do except, of course, when he's bound in this wheelchair. I did a poll last week, and I thought it would be kind of cool to put that in this, which is, should the trials be broadcast, the ones involving Brooks? And it got about 500, just under 500 votes when I checked it. And it ran about 3-1 in favor of broadcasting them. And that's the broad majority, right? And I agree with that. I do think judges should retain control of that situation because broadcasting can impede a fair trial and things like that. But I think it's generally helpful for the public. So I'm with the majority on that. But I will say that if a judge doesn't broadcast a trial, doesn't mean it's not public. People can still go to the trial. And very few trials, percentage-wise, in the United States are broadcast anywhere. And federal trials are not broadcast. So broadcast trials are the exception. But I think it's good to see the government in action and to see how these trials actually work. I think people can learn from that. So I'm generally in agreement with that. Even though he's a clown show and all of that, still, I think the benefit is there, even for this nut bag. Let's take a look at Lori Vallow because she got the Oh My God Brigade going with a motion for new trial with some of her post-conviction action. And it had several grounds in it. Too bad I don't have the graphic for that. But some of them were technical legal things, and so I didn't see that commented on as much. One was, hey, you said the conspiracy was going to you said the conspiracy was going to involve 5 people or more, but you really only showed it was 2, so that's totally unfair. So throw out these murder convictions, conspiracy convictions. Yeah, I don't think so. The other one was that you changed the indictment at the close of evidence, and you did it in a way that was unfair to us. So you can change that pretty much anytime, but you can't do it to the substantial prejudice of the defendant. So if you're charged for one crime and then you get all the way through the trial and they change it to another one that you weren't prepared really to defend, that obviously would be unfair. And if you just changed it for some technical typographical error, it'd obviously be unfair to throw the conviction out. Somewhere in between there is common sense, right? So they're saying that the state changed the indictment in such a way that it changed an actual element of the crime. And so they, it was unfair for them because they didn't pursue disproving that or putting the state to its test of proof for that element. I didn't check into that too closely. I'm going to be dubious of that because you always get these motions for new trials and they're rarely successful, but they need to be made. And I understand it. I don't know that there's merit to that. What got people's attention was the part about the juror interview, that the jury instructions were confusing and that the juror knew of evidence that wasn't presented at the trial, right? That's what people want to hear there. Jury misconduct, that these people were out researching this trial and they shouldn't have done it. And it's totally unfair. Well, it's not exactly backed up by the facts. And by not exactly, I mean not. So the juror responded on East Idaho News YouTube channel, which is a great channel, saying, no, the instructions were clear. I wasn't confused about anything. And more specifically, there's a picture from his broadcast. The juror said, also, by the way, that evidence that I talked about that wasn't in the trial. Yeah, well, I watched a lot of videos of this after the trial was over with my wife, and I saw this stuff in Arizona. I'm like, man, too bad I didn't pick up on the red flags there. So the juror did not see that stuff during the trial. I saw it after and commented on it like any citizen can after the trial's over. And also in terms of the jury confusion and the defense saying, well, this was 404B character evidence, not demonstrative evidence. It shows the jury doesn't know what they're talking about. So look at the juror. He said, we didn't consider this during our deliberations. So this is evidence that the defense says, well, it shouldn't have been let in because it really was going to be kind of confusing. And this guy says, we didn't let it play a role in our deliberations. You think they're going to throw this verdict out because of that? No. They're not going to put these jurors to a test of law school and make sure they understand how to refer to each rule correctly. And especially when the juror says we didn't even consider that, and it's stuff the defense didn't want considered. So they're making the motion and all that, and it got some traffic because of the juror gave the interview, and then they made some, the juror looked at evidence he shouldn't have, but that was completely groundless from, it appears, from what the juror has said. So here's a comment here that says, I think broadcasting helps lift the veil. And I agree with what you're saying there. I mean, I agree with that. It's also, when I first started being a lawyer, going to court and not having experience with the legal system, trials weren't really what I thought, and they operated differently, and the dynamics are different and things like that. And you still don't catch all of that on TV, but you certainly, I think, if you watch a trial, you've never been to one or been in a big one, then you learn, wow, there's a lot of things going on here, just that other than one side tells a story and then the other one tells their story. A lot of things involved in it. So let's see here. Okay, so she's going to have other things. She's got a motion for new trial. She's got sentencing and appeal. And she also has some fun awaiting her in Arizona because she's got indictments for conspiracy to murder and maybe some other things too for her ex-husband, Charles Vallow. And I guess this was her nephew-in-law or something like that, Brandon Boudreaux, that she was involved in trying to kill him. He made it, but Charles Vallow was of course shot and killed in very suspicious circumstances. So why continue to do that? Well, I mean, these people were injured by her activities, the state says, so they should do it, I think. Kind of like the Erica situation. That's just my opinion, and everybody can have their own. This chick right here, man, her story is just really bad and a cautionary tale for if you're going to do drugs, do the good ones, okay? Because, she is on trial for murdering her boyfriend and then mutilating him, cutting him up into pieces and things like that, and then sexually assaulting him, allegedly. So her appearance in court a couple times back was this, where she wasn't satisfied with her lawyer and let him know that here's a clip from that. Now, clients often wish you pursued things differently than what you're doing, and they'll let you know that. And I think that's fine. I can say I've never been physically attacked in the courtroom, but it has happened. However, she went from that exciting moment to this, where I think they got these things around her arms now, and you can see that she's T-Rexing it there a little bit. And the lawyer would kind of, if she wanted to choke this lawyer, I think it would have to be consensual. The lawyer would have to put his head in between her hands because her mobility is very constrained. Her boyfriend should have bought this kit off Amazon, maybe, if he knew what was coming. And that's going to bring us to this weird part. Okay, I've already mentioned her charges. Well, they've asked, for all the motions her lawyers are filing, things like that. And they want this third charge dismissed. They got other motions too. They've asked for change of venue. They didn't get it. They've asked for bail to be reduced. They didn't get it. They're asking for the evidence that was found to be suppressed. Her statements where she did say, I did all this stuff. She wants that suppressed, and this dismissal. Also, bizarrely, they've asked for the prosecution to be excluded from jury selection. I've never thought to ask for, hey, judge, can you kick the other side out while we're selecting this jury and just let me and you do it? Never thought of that one. So that's interesting. Anyway, this motion to dismiss count 3 is where you may have seen this on the news a little bit, because part of the argument is that it can't be this type of assault because the person was deceased. Okay, so they're not a person anymore. And in this case, they were in parts. So it wasn't a person being assaulted. It was only a part. I don't know if you can read it there or not, but I found in the statute a subsection that says, hey, for this grade of assault, it doesn't matter if the person was deceased at the time. So they already thought of it. Looked to me in the legislature that someone's going to kill somebody and say that it doesn't count because of that. But they didn't think far enough ahead for this lady, who was also saying, yeah, but what if you also chop them up? So I guess the court's going to have to look at that carefully, unfortunately for that judge. And I think that motion is under advisement. The state is arguing that it's a person and all that. I haven't seen all the briefs, so I don't know exactly what's going on and how they deal with this subsection of the statute, which to me seems to support the state's argument. But it's a little bit novel that if you've chopped the person up into pieces and say you're only interacting with one piece, maybe it doesn't count as this type of assault. That doesn't help her with the murder part, though, however. All right, this came up when we talked to last time, some of the Darrell Brooks stuff, and it's a question that gets raised every once in a while. Sometimes people say, what is Darrell Brooks talking about when he's mentioning this dumb argument or that dumb argument? And so I did look this one up because it got brought up again, and it's kind of a funny one that I also bring up, and that is the flag fringe. Okay, so let's get into that. So the idea here is, from a Brooks and people like him, is that if you have fringe on the flag, there's the bottom one, versus a flag without the fringe, that's the top one, or an eagle on top, it means you have no jurisdiction. And therefore, apparently, he can just go free for murder, that it's an admiralty court. Okay. And that if it has fringe on the flag, it's admiralty court. And God bless people who ask this question, but I have to say, think about it. Just think about it. It doesn't matter what flag they have in a courtroom, or if they have a flag. I've never even crossed my mind ever in any court setting the relevance of a flag to the jurisdiction of the court or the proceeding that's going on. And however, he's not novel in this. He didn't think this one up. This wasn't. He's sitting around doing original legal research. This argument has been around for a while, and the skepticism has always been there. And here are a couple of cases. Maybe you can read them from federal court. I've got them down here where I can tell you what has been said in the past. So here's a motion for summary judgment, identifying the court as an admiralty court. It's a jurisdictional challenge, but this motion is denied. Others have attempted to persuade the judiciary that fringe on an American flag denotes a court of admiralty. In light of the fact that this court has such a flag in its courtroom, the issue is addressed. The concept behind the theory the proponent asserts is that if a courtroom is adorned with a flag that happens to be fringed around the edges, such decor indicates that the court is one of admiralty jurisdiction exclusively. Then the court starts the dunking process, saying to think that a fringed flag adorning the courtroom somehow limits this jurisdiction is frivolous. Petitioners claim that the court lacked jurisdiction because flag was fringed as without merit and totally frivolous. I mean, they're really trying to be clear here, right? Unfortunately for the defendant, decor is not a determinant of jurisdiction. Here's another U.S. federal case down at the bottom. The remaining claims that petitioner has asserted by way of motion to dismiss, e.g., court lacking jurisdiction because the court's flag has yellow fringes on it, were denied. The court considers them to have not only been without merit, but also to have been totally frivolous. There's no arguable basis in law or fact. The appeal is not taken in good faith. So, yeah, whether they move a bench around a courtroom or the flag's big or small, or they turn it this way or that way, it's frivolous. And actually, when I checked this a little bit, I even saw other sovereign weirdos saying, please don't make this argument. The flag doesn't decide the jurisdiction. They're still trying to claim, like, if I call myself accused versus defendant, I can get out of this and stuff. But they are even admitting to themselves, stop with the flag argument, because it's just too stupid. It's too stupid for people who even think as long as you use a certain word that a court can't do anything. Now, there are arguments for jurisdiction because courts are limited in jurisdiction. They're limited in subject matter, and they're limited in scope in terms of geography and the people that they cover, right? So we've talked about that a little bit on gag orders. Like a county court somewhere across the country issues a gag order. It doesn't affect everybody across the nation. They don't have that power. So sometimes the jurisdiction argument is appropriate. It is never appropriate based on which flag whoever decorates the courthouse decided to buy. That one doesn't work. Yeah, I like this one. So that's a good point. You got to look at what color the walls are painted. And I think this is true. I mean, Brooks was not doing something original. And these arguments, like if you look at these dates of these cases, these things are decades old. This stuff has been around for a long time, and they're not, the arguments aren't getting better with age. These are not a fine wine. These are like milk left out in the hot summer sun. It just gets dumber and worse and stinkier the longer you leave it out there. So I will also comment, since we're talking about Brooks before we wrap up, that somebody mentioned, hey, about this no merit appeal situation, that his attorney, Michael Covey, has filed a no merit report in the Chandler Halderson case where the guy killed his parents. So I looked that up, and it looks like there is a no merit report coming. I can't see that it's actually filed yet, but it does say, that it's due in. So I assume he's going to file that. And the question was asked, does that mean he can't appeal anymore? And people often ask that about Brooks. If his attorney files no merit report, is that the end of it? Well, that's no merit stuff is kind of complicated because he could dispute that, and Halderson can dispute it and say, hey, that's unfair. There is merit to my appeal. And the attorney's report will be reviewed by the Court of Appeals. But if it does, and the Court of Appeals could reject that and say, no, there's a basis here to at least argue it. Go back and look at it again, or we'll get you a different lawyer. So all that stuff could happen. But if it does stand, then what it does mean is you don't have any state paid appeal. But prisoners file appeals when they want to sometimes, and they can come up with a new reason. And sometimes they can be legitimate, not for Brooks, because he's not going to find evidence he's innocent or something. But you can appeal later in some situations. And look at the Mark Jensen case, which was in Wisconsin. That guy kept appealing over and over, and he lost at the state courts. But then he appealed over in federal court, saying his federal constitutional rights were violated by this letter that his wife had written being admitted into evidence, and they agreed. So he ended up with a new trial, and after like his fourth appeal or something like that. So I can't tell you that just because you get a no merit report, you're never going to see this dude appeal again. But in terms of the state paying for his appeal at the state court, this ought to do it for him. So and now I don't know whether Covey's going to say Brooks has no merit to any appeal or not. He hasn't said yet. He doesn't even have the record yet. So we'll just have to see on that. But he has done that for Halderson. So I have seen his attorney in some cases actually file appeals with briefs asking the court to reverse the conviction of people because of material error. And I've seen this guy file no merit reports. Doesn't that indicate he's looking at the record and trying to make a reasonable decision on whether an appeal has merit or not? It seems that way to me. And so he's going to look at it, and we'll see what he does. I could see that he could come up with a reason to make an argument for Brooks, like, oh, the venue should have been changed or whatever. I mean, some people say it should have. I think the judge did the right thing here, but could you appeal it? You could. Is he going to do that? I don't know. Is he going to say some things happened during the trial it shouldn't have? We just don't know until he finishes getting the record and going through it and all that. And I think this is true too, that Brooks, he must be prosecuted for remaining crimes. I think he ought to be, okay, because that is justice for the victims. I agree with that. Yeah, and Vallow, of course, the guy didn't broadcast that. He let the audio out, I guess, at the end of every day, so that kind of blew a lot. There was a lot of publicity. The judge has to have some control over the courtroom because live broadcast sometimes nuts come in off the internet and try and interfere with witnesses and things like that. We know that. So the judge has to keep an eye on that and just make the best decisions they can. So written notice of appeal. Yeah, generally, I mean, every state is right. It has different deadlines. So the notice of appeal actually here, as he's filed a notice of intent to appeal, and then when the transcript comes in, he'll file a notice of appeal, and then all the regular schedule will start. Having said that, for example, like in the Jensen case where it went all the way up through the Wisconsin courts and they said, nah, we're going to let the conviction stand. He then was able to go to federal court and appeal over there, saying that they made a mistake in the state court because usually the federal court wants you to exhaust your state remedies first. So appeal after appeal. And then sometimes you can appeal because something was discovered later, right? So, if a piece of evidence comes up, then there's a test that you go through, whether you should have known about it and whether you were just being dilatory or whatever. But you wouldn't want someone to come up with some evidence to say, hey, this proves I was innocent, or hey, this terrible thing happened. The judge was paid $1 million to hold this evidence, and we just found out about it, and go, hey, the deadline was 10 days. And even though you couldn't have known it before that, you didn't file it before that. So there is a criteria to allow these things after deadlines, but it's a test that you have to go through because there generally are tight timelines for appeals, and appeals usually are very technical, especially on civil cases. In criminal, there can be a little more leeway because the person's incarcerated and you want substantial justice, right? You don't want technicalities. You want real justice. And real justice isn't considering appeals over and over again that are frivolous, but it's also not throwing something out that has merit, that not the fault of the defendant. He just found this out. So I can't say that a guy's never going to appeal again if this one gets tossed as a no merit, but it's the end of his run with state paid appeals, it looks like to me. So let's see what else here. That's all I had for today. These are usually pretty short, and this one's actually gone longer than normal, but it's fun for me to see comments in this. And that's it for this week. Next week, I'll try to broadcast the Daryl Brooks thing if it happens, and we'll see whatever else happens. But wait, let's catch this here. I don't know if this is true or not, but I can't not click on it. I feel like if you beat the crap out of Brooks, there'd be nothing of him left. So I could believe that someone beat some of the crap out of him, but since he's 99.99% that, they probably didn't get it all out. Oh, I see now it's a joke. See, this is how slow I am when I'm reading these comments. Okay, thank you. Yeah. So you're way ahead of me on that one. I didn't read it all first. This is how naive I am. Do I believe it would be granted a new trial? I disagree that the venue should have been moved. Yeah, so moving the venue is again, I did a video on that and went over the case law and stuff. There's a series of factors the judge goes through to consider that. And it's not automatic because in theory, you should actually be tried in the venue where you committed the crime, and you are and stuff. So however, it can be moved. But also, if the case is affected by a lot of publicity, the judge has different things they could do, including jury questionnaires and other things that the judge did in this case. So there's a lot of factors. What I'm saying is, whenever you have something that involves a lot of factors that the judge has to weigh, you could usually make a case to appeal it. Doesn't mean it's a great case, but you usually can have a case and say, well, they should have weighed this more than that. Now, generally speaking, I agree with you that it should have stayed where it was. I agree with that. I'm only making the point that potentially you could argue it, but I think the Court of Appeals would probably find in this case the judge did the right thing, that he was not prejudiced by being tried where it was. Really, I mean, I'm sitting in North Carolina and I knew about this scumbag, so where is he going to go? That people don't know about this crime. What you're looking for are jurors who can be fair, not jurors who never heard about it at all. There is this concept on social media that the jurors must be like pristine monks from some Buddhist monastery on the side of the Himalayan mountains, and they come down and they've never been exposed to modern civilization. They don't know anything about anything. That's not the standard. They can know about the case. They even can have read about it. What you're looking for is whether they're prejudiced or not, whether the information they got is, unfairly prejudicial. Are they going to be able to have an open mind, and are they so tainted they shouldn't be on the jury pool? That kind of stuff. So yeah, you live in Virginia, you're aware. And like I said, I'm in North Carolina, same thing. I don't think you'll get a new trial because I don't think those arguments work. I don't think the jury composition argument works. You'd have to find something that happened during the trial, in my opinion, that is reversible error, because not just any mistake the judge makes results in the conviction being thrown out. It's got to be something that would have been material, right, to the conviction. And how bad the mistake is, it depends on it to get it thrown out, depends on what you're talking about. A constitutional right gets looked at more carefully with less deference to the judge versus an on the move decision on evidence that is only ancillary to the main part of the case, right? I mean, that seems fair, right? Because otherwise, the Court of Appeals up there just retrying cases, and that is not what appeals are for. They're looking for whether there was material error that would result in an unfair trial, that the conviction should be thrown out and redone again. They don't reweigh evidence and stuff. They're looking to see if the judge made that kind of error. So that's what goes on in appeals. It's almost completely a paperwork exercise. When I looked at the Wisconsin stuff, most of these didn't even get an oral argument. And then when they are oral arguments in the Court of Appeals, it's not your client sitting there blabbing and stuff. And it's a very time limited, very tight time limit situation. If you look at the case in Michigan with the parents that got charged for their son going into the school and shooting people, that went up to the Michigan Court of Appeals pretty quickly. In that case, the oral arguments were televised, and those are reasonably long arguments for a state case. And it was good back and forth with the attorneys, and you can watch that, but not long, right? I mean, you're talking about an error of law. And if you're talking about an error of law, then you should be able to present it on paper to the Court of Appeals, and they will often just decide it on that. There rarely is a mind change during oral argument. So that's what I've got on all of this. And I really appreciate that, and I appreciate you guys watching. And I'm going to mention this again because Marsha Lynn has supported the channel many times, and it's encouraging to see that, and it helps me upgrade things. So I appreciate it. And thanks to everybody who tuned in. And I'll probably be on Eric's broadcast later on, so people can criticize me for my opinions on things there that aren't necessarily legally related. And if anybody has questions about other cases and stuff like that, throw them in the comments to this, and I'll look at it for next week. I try and accumulate something that I see that goes, wait, what, during the week. And then at the end of the week, sometimes I'll record parts of it during the week. That's why it's often not me on here, and then put it together at the end of the week. But sometimes I have time like now where I can do it. But if you're like, I think there's more to this than that, what's the legal angle? If I can figure it out, I will, because that's the kind of stuff that interests me. We all can have our own opinions on facts. And my opinion on facts are no better than yours and no worse than yours. But sometimes, just due to experience I have, I can pull a legal document and say, well, did you know this or did you know that? That's what I'm trying to help you with. And everybody have a good rest of the day and a good weekend. Thanks. Bye.